Did you know that there's 8 ways to hold title in the state of California when you go to purchase a home? In this video, I'm going to go through every single one of them so that you're better informed. So stay tuned. Hey everyone, this is Josh V, your probate realtor here in Los Angeles. In this video, we're covering the 8 ways to hold title when you purchase a home in California. And before I dive right into the video, I just want to make a small disclaimer that this is not intended to be legal advice or anything like that. So it's important that if you have a question regarding the vesting and the way to hold title, that you speak to, number one, either a title rep or a real estate attorney that it will be able to guide you through this process. I specialize in probate, trust and estates here in Los Angeles, so I am sharing this experience or this information based on experience that I see on a daily basis, where I look at grant deeds and I see the way that people hold title and how to avoid probate. Let's jump into the video. Like I was mentioning earlier, there are 8 ways to hold title when you purchase a property. In California, you go through a third-party company called escrow. And through the escrow process, they will send out escrow instructions for the buyers. One of the forms that you will receive is a vesting. Basically, how do you want to hold title and vest the title? And so there's 8 ways to do that. Number 1, if you're just one person purchasing the property, you could hold title as sole owner, meaning just you. Number 2, if you own the property between 2 people, there's several ways that you can hold title. Number 1, you can hold title as joint tenants, meaning that I have 50% of the property and the other owner has 50% of the property. So if something happens to me, my 50% goes to the other homeowner. Number 3, you could hold title as tenants in common, which basically means I have, say, 60% interest, the other homeowner has 40%. So it's a divided interest. Number 4, you could hold title as a revocable transfer upon death. What that means is as soon as I pass away, I have a document saying that the property is automatically to go to X person, to somebody else that I've designated. Next, you have community property. This is primarily for married couples. Say, me and my wife are married, we hold title as community property. The only downside to community property is that my 50%, right? So I have 50%, she has 50%. When I pass away, I could will my 50% to somebody else. So if I had another child from another marriage, if I had a mistress on the side, I could literally give away my 50% to somebody else and leave my wife hanging dry. But the next one is community property with right of survivorship. So that means that I hold 50%, my wife holds 50%, and as soon as I pass, my 50% automatically will go to her, leaving her to become full owner of the property. The last 2 ways are to hold title as an LLC, limited liability corporation, as a company. Right, so you can create that through the state, or you can also hold it as a living trust, which is the best way that I recommend. If you own property in the state of California, I highly recommend that you have a living trust in place. What that does is it's going to have direction to your family beneficiaries, a fiduciary if you don't have family, or to the estate planning attorney as to how you want your estate handled after your passing. So that is the 8 ways. I hope that this information is helpful to you. Again, this is not intended as legal advice. If you have any serious questions or particular matters, please contact a title rep or a title company. There are numerous title companies out there, Lawyers Title, Fidelity, Chicago, you name it. Or speak to a real estate attorney. They will be able to better guide you as to the particulars with your particular case. But if you have any other questions outside of that, please do not hesitate to contact, text, or email me, or call me, and I'll be happy to help. You'll be glad you did.